The funding for this program is provided by the Corporation for Public Broadcasting and the Friends of 4, 10, and 12.
The Idaho Supreme Court. In its latest reapportionment ruling, 4 of the court's 5 members became involved in verbal fisticuffs. Tonight on Law Day 1984, we take a look at Idaho's High Court and the decidedly injudicious language of some justices. Good evening. 3 weeks ago, the big political news in Idaho was the state Supreme Court's rejection, for perhaps the final time, of the state legislature's reapportionment plan. It was a ruling that turned out upsetting most Idaho politicians, Democrats and Republicans. But it also engendered an unprecedented judicial exchange among 4 of the court's 5 members. This Supreme Court flap of the last few weeks has absolutely fascinated lawyers and other court observers, both because it is so unusual in Idaho and because it offers a glimpse, perhaps, of how the High Court operates. Tonight, with a former state Supreme Court justice, with 2 attorneys, and with a journalist, we probe this area, the operation of the Supreme Court, an area that is usually reserved for legal scholars. The state's court of last resort is made up of 5 justices, each an attorney elected at large on a nonpartisan ballot to a 6-year term. Midterm vacancies on the court are filled by the governor. The justices decide among themselves which is to be the Chief Justice. The current Chief Justice is Charles Donaldson, a former Republican legislator. He was first elected to the court in 1969. Donaldson had been Ada County Justice of the Peace and then a district judge. Alan Shepard was also elected to the High Court in 1969, following 2 terms in the Idaho House of Representatives and 6 years as the state's Republican Attorney General. In 1971, Robert Bakes was appointed to the court at the age of 39 by Democratic Governor Cecil Andrus. Bakes had served as an assistant U.S. attorney for Idaho and was a senior partner in a Boise law firm before the High Court appointment. A northern Idaho attorney, Stephen Beislein, was appointed to the Supreme Court by Andrus in 1976, following the recommendation of the state's Judicial Council. Beislein has been noted for his sharp dissents from the court's majority. And the court's newest member, Robert Huntley, was appointed last year by Governor John Evans. Huntley is a former Democratic legislator from Pocatello, an attorney well-versed in water law. In theory, at least, as a nonpartisan body, the state Supreme Court is supposed to stand apart from legislative and executive branches of state government, rendering politically disinterested judgments. But a number of recent rulings on water and utility issues, and most recently on reapportionment, have prompted some court watchers to see the Supreme Court as just 5 more players scuffling in Idaho's political arena. One example. Last fall, the court decided that utilities could charge customers for construction work in progress, or CWIP it's called, before utility projects are complete and useful to ratepayers. It was the latest in a long series of opinions overturning rulings by the Idaho Public Utilities Commission. In dissenting from the CWIP ruling, Justice Beislein broke the usual bounds of judicial decorum and criticized the court majority for usurping the powers of the Public Utilities Commission. It is not this court's province to be a super commission, but merely to determine whether the commission has abused its discretion in setting confiscatory and unconstitutional rates. Beislein wrote, adding, "It is this court which oversteps its bounds and acts outside its jurisdiction, and thus unconstitutionally in the setting of rates." The trend toward verbally abusive opinions was brought to a new level 2 weeks ago when the High Court issued its latest reapportionment decision. In a 3-2 ruling, the court overturned the redistricting plan passed in the final hours of the legislative session, adjudging it in violation of the one-man, one-vote principle and charging the legislature with gerrymandering. This time it was Justice Bakes and Shepard who dissented. Bakes said the majority, in a, quote, rush to judgment, had trampled upon the due process rights of the defendants and the legislature. In his dissent, Shepard accused the majority of a stampede to judgment, obviously designed to reach a foreordained result. Bakes concluded with the unprecedented suggestion that the defendants in this case, the legislature and other state elected officials, sue the court majority in federal court to overturn the decision and collect damages and legal fees. Within a day, Justices Huntley and Beislein, in another unusual move, issued rejoinders to the dissents. Huntley replying, "The dissents have grossly misstated the record and are totally in error. and concluding, "The suggestion by the dissent that the defendant should bring a civil rights action against the majority of this court is certainly novel, a disingenuous attempt at intimidation, and might be thought of by some to indicate a lack of even a modicum of judicial approach and detachment." Did anyone ever believe that either legislators or jurists could maintain decorum and a sense of humor while undergoing reapportionment proceedings? Beislein's response was even more pointed. "One cannot accept in good grace the tenor and content of the dissenting opinions," he said. "Disgruntlement at not prevailing in advocacy ought not to lead to distortion and perversion." Beislein went on to characterize the due process argument of the dissenters as pure vent-spleening, unworthy of comment. Then, following some 20 pages of comment, Beislein entered an uncharacteristic personal attack on one of the dissenters, Justice Shepard, who had written that the court's majority was paranoid. Beislein saying, "While ordinarily where paranoia is concerned, I yield to the views of Justice Shepard. In this particular case, nothing surfaces but a case of sour grapes." Some more now on this unusual and pointed language from the justices on the state Supreme Court and what it might mean. Our analysis tonight from Henry McQuaid. Justice McQuaid served on the Idaho Supreme Court from 1956 to 76 when he resigned to accept a federal government appointment. He is now in private law practice in Boise. Phil Barber used to be Justice McQuaid's law clerk. He now practices law also in Boise. Craig Lewis teaches law at the University of Idaho Law School in Moscow, where he joins us tonight. And Jay Shalladay is the editor and publisher of the Daily Idahonian newspaper in Moscow. Mr. Shalladay is a longtime observer and sometimes a critic of the state Supreme Court. He's also with us tonight in Moscow. Jay Shalladay, let me start with you. Are these 5 justices guilty of just a breach of decorum, or is it something more than that?
Well, my opinion is that we've held these courts much higher than they should have been. When you're dealing with a political subject like reapportionment, you're dealing with personalities that are political and have political backgrounds for the most part. How can we expect them not to get political when they're rendering their decisions? And I don't think it's any secret that there's a lot of animosity between certain members of the court, and when you get into a situation that requires a quick judgment, a quick opinion from the court, and it's going to be a political one, these sorts of tendencies are going to surface. I think it's healthy. I don't have any problem with it. I have great problem when you're hiding your animosities towards the other justice.
So this, even though these fights usually take place behind closed doors and they're hashed out before the opinions are written, are you suggesting it was just the subject of reapportionment that brought this to the surface?
No, that I think was the catalyst. I think this has been simmering for some time between, for example, Justice Beislein and Justice Shepard, Justice Huntley, and perhaps the Bakes was the one that was really the ringer on this. I didn't expect him to be as pointed and as a matter of fact to encourage the defendants to bring a lawsuit against the majority, which I think is a rather novel idea too and perhaps has merit.
Mr. Lewis, Mr. Shalladay seems to be saying that he's not too terribly surprised by all of this. Are you?
Well, that's a tough one to answer. I think the nature of the language used in the opinion is certainly unusual. I think the fact of disagreement among appellate justices is not at all unusual, nor is dissent. I think what may be particularly unusual about this decision is the timing. And this may be just an example of a situation in which the justices did not have the usual opportunity that they would normally have to talk about and hash out disagreements in private in their conferences. I think this opinion was issued, the majority opinion was issued in something like a week from the time the matter was brought to the court. So I think, I suppose for a short answer, I would say that I suspect these kinds of disagreements occur quite frequently on appellate courts. I think the circumstances may be what led to the exposure of the extent of the differences in the opinion.
Yeah. Justice McQuaid, how do you view all of this, and should we be making much of it?
Yeah, from the observations of Jay and Craig, it seems like they're saying that this is an in-house disturbance that has been vocalized to the public. and it enunciated itself through the political opinion where the redistricting was the catalyst. From my experience, I doubt that the political arena that the legislature found itself in on the reapportionment didn't boil over to the Supreme Court. And I really don't subscribe necessarily to the in-house differences between 5 men who live together most of every working day. Really, it isn't that sort of a thing at all. It comes about, as I view it, more as technicians who are jealously guarding their prerogatives as technicians through the office which they hold. And when they do come about to the position where they feel that another member of the court is not vocalizing through the instrument of the opinion the accurate view, whether it be legal or a fact-finding, question, then they are inclined to be not intemperate, but a little more outspoken. That would be my view.
Mr. Barber?
Well, I agree with one thing that has been said by everybody, and that is the necessary speed with which the court was pushed into the position of reapportionment, the lateness of the legislative action, the impending election. I think that courts are, appellate courts are deliberative bodies, and they deliberate among themselves. And one of the things that just leaps out of the opinions in this instance is that they didn't have the time to exchange their draft opinions and their draft dissents so that they could work out where they were and attempt to persuade one another in the way that is described in Bob Woodward's book, The Brethren of the United States Supreme Court. But I really don't think that, although they were a bit outspoken and this was a very big political issue and therefore it got a lot of press time, I don't think it's unprecedented that men who are spirited, that were advocates professionally, do occasionally, when they're judges, sound like advocates again. It happens rather regularly.
I think what a lot of people, though, are seeing as really uncommon here is the suggestion by one of the judges that maybe the majority was liable for a lawsuit because they had handled it so badly.
Well, I didn't read it that way. I read that as an advocacy kind of statement by a judge who had been trained to be an advocate and had been an advocate. It sounded like a suggestion of the sort of thing that's wrong with the majority, so why don't we get on with writing it, which is the kind of things that justices of all appellate courts do in dissenting opinions. I think if there's any stridency in this instance, it was really forced by this very foreclosed period of time that they had.
Mr. Chaladay, do you have a comment on that?
Well, I don't see how you can read it that way, Phil. Bates says that it would be appropriate for the defendants to seek damages, costs, and attorney fees for the action against the majority. But in any case...
Well, you've got to admit, though, that that's pretty unusual to have one judge saying that the principals in a case maybe should sue another judge because he'd done it so bad.
Oh, it's unusual. As I said before, I don't know that I think the theory might have some merit. I didn't mean to imply when I said it had merit that this particular defendant would have merit in suing the majority of the court. I don't know that. I also take issue with the speed in which the court was pushed into this. I don't think anybody was taken by surprise at the arguments or at the facts of the case. It's been around for more than 2 years, and everybody knew where it was heading. No lawyers were taken were unprepared for this or taken by surprise. The arguments that Bates puts forth that there wasn't due process, it seems to me that any attorney that didn't know what was going on in this case or was taken by surprise, the defendants might have a prima facie case of malpractice. Everybody knew. It was in the press, it was in the legislature, it was the topic of conversation, and if we waited and deliberated for 10 years on this thing, we'd come up with the same conclusion that 33% deviation just won't stand when you have a plan that calls for 10% deviation.
Mr. Chaladay seemed to be saying earlier, well, I think he said it earlier, that there are sharp differences, and it's not any secret that there are people on the court who maybe not only don't agree, but don't like each other. Mr. Barber, is that fair?
I'm not at all sure that that's fair. I've been involved in the appellate process in the state since I had the good fortune to be Justice McQuaid's clerk in 1969. I've known a lot of the Supreme Court justices present and past. These men are spirited advocates, and they are regularly spirited advocates. There are heated exchanges in opinions. If you want to read a heated exchange, read almost anything that Justice Black in his latter days in the United States Supreme Court wrote about anyone he disagreed with, almost all the time. That doesn't necessarily mean that the same people won't go out and play tennis or play golf or otherwise socialize shortly after they exchange these kinds of heated exchanges. I just simply disagree that you don't find this excepting this time. You find it. There was a guy named Musmano on the Supreme Court of Pennsylvania who delighted law students of, I'm sure, Mr. Lewis and everybody else for generations because of the rotten things he said about his colleagues on the bench. It just happens. This time I think that the time pressure wasn't one on the lawyers, it was a time pressure on the justices. They came to a conclusion and they came to opinion writing in a much, much shorter period of time than they usually accord themselves.
Well, Mr. Lewis, let me ask you, is it good in a public sense that these sorts of disagreements, if you will, get aired in public, as this one has been?
With respect to dissent in general, I would say definitely yes. And I suspect the other panelists would agree with me that the dissent plays a very important role in judicial decision-making. I think we have to remember that these cases that we're looking at, reapportionment case being just one example, are cases that have not settled and have reached the highest court of a state, and they are close cases. Parties have written lengthy briefs on each side, each party believing they're right. And of course there is a strong position to be made for each side. It's not surprising then that you would find disagreement among members of a court, and I think disagreement is the rule rather than the exception. And I think the function of the dissent is sometimes it leads to reform. The dissenter can lay out the reason or reasons he has for his position. That can and does lead to future reform and future change of decision by a majority. And it airs the policy, competing policy considerations. So I think airing differences in cases of this moment is a very important function.
What about airing them, though, in this manner, Judge? I had one lawyer who declined to be identified for the record who said that he thought this type of language, the circumstances of this case aside, did something damaging in that it portrayed some sort of bad public, left some bad image with the public.
Judicial writing doesn't encompass personalities. Whatever personalities did creep into this particular case is not the best formulated opinion. It's strictly within the rules of good writing to criticize as a technician the majority of an opinion. The majority never criticizes a dissenting justice. But in this instance, we
Although they did in this case.
In this instance, the methodology, I think, that was used in the formulation of the opinion, and knowing the process intimately, I can sympathize with the observation that perhaps the court was rushed into the rendering of the opinion without the opportunity to fully explore the meaning of the various opinions that were written. So in substance, I would say a good opinion does not deal in personality. They deal strictly with the legal question. They do get off on the factual issue, which is not uncommon at all, because like juries, they have a minority and a majority view. But a dissenting opinion is probably one of the healthiest tools that we have in judicial writing, and I certainly subscribe to it. I know that there's been some criticism by members of the court writing too many dissenting opinions, but I can't subscribe to that because
Justice Breisline's been criticized by some for that.
it may be. But those opinions show a greater amount of work that goes into the dissent oftentimes than goes into the majority opinion. We as technicians in the field explore those dissenting opinions very carefully, and oftentimes they're a source of knowledge that is not otherwise available to the bar throughout the state.
I hear what you're saying. Mr. Shaladay, let me ask you a question I'm relatively sure you have an opinion on, and that's beyond the scope of this particular case. How good is this court?
Well, I don't know. I don't think I've ever addressed that point. I've addressed individual decisions and the rationale that goes into some of those decisions. I would feel more comfortable saying how good is an individual justice rather than the court. I don't think this court is any better, any worse than the past courts, and I haven't been around that long to be able to compare it, let's say, with a court of the 1940s. I would suspect that the staff is better, and I would suspect that the clerks are better trained to deal with facing the complex issues. But how good is this court? I don't know. It's a political court, for sure.
What do you mean by that?
Well, I think well, let's see, 4 out of the 5 come from political backgrounds, legislative background. They run for a political office on a partisan ticket. They still keep close ties with their parties. I think this is probably the most political court of all, and I don't have any problem with that either. I don't think that the court is any less political in essence than the legislature.
Is that true, Mr. Barber?
Yes and no. I have to agree with everything that Mr. Shaladay is saying in terms of the background of this court. On the other hand, that's sort of what we ask for. We're a populist, progressive state in terms of the way our Constitution says we got to select judges. And we're very fortunate in Idaho. We've got frankly, a very good judiciary. There are times when even I would disagree with occasional opinions of one or more judge, and they generally know about it. But that doesn't mean that because we have opted to be political, they are more political than any other court similarly situated in the West.
The fact that these people, most of them, have some partisan political background, be it identified as a Democrat or Republican, that's not bad in and of itself.
No, it's typical, in fact, for most states similar to Idaho in terms of how you select your courts.
Well, Jay Shaladay, let me try again. You've been particularly critical of one judge, Alan Shepard.
Mm-hmm.
Why?
Well, I think he allows his personal prejudices and his biases that are on the non-political level to get in the way. I think that he doesn't need, in certain cases, to even read the briefs. He's already got his mind made up and will roll. And there are non-political issues, and I think he takes his emotions to the bench with him, and I think he takes his background and his prejudice to the bench with him, and I don't think anybody has a fair shot in front of Justice Shepard. Now, there's a lot of people who will say otherwise, but you asked and I told you.
Yeah, anybody else here say otherwise?
Yes, somebody has to, or else there's no conversation.
If you're practicing in the state of Idaho, I would urge you to take exception.
Justice Shepard has certainly not ruled in my favor on a number of occasions when I've appeared in front of him. That doesn't mean that I share Mr. Shaladay's opinion because I've not been able to convince him. I think that Justice Shepard is a pretty conscientious judge. He's a pretty conservative judge, as judges go today, and yeah, his conservatism comes out, but that is a part of the notion that you're going to have a populist or political kind of court, which is a notion built into our Constitution. He was selected under a Republican administration. He is the sort of person you'd expect to be so selected.
Mr. Lewis, I mentioned Justice Breisline and his dissents earlier. He's received some considerable press attention for the number and frequency of his dissents. Is that good or bad or a wash?
Well, I personally think it's good for some of the reasons I suggested earlier. I think the question probably should not be whether it's good or bad. It is Justice Beislein expressing his opinion in these cases. He is a frequent dissenter. Any lawyer in Idaho is well aware of that. I think that, in my own opinion, that may reflect something of a difference of judicial philosophy he has, perhaps with some other members of the court. I see Justice Beislein as perhaps more result-oriented in his view of what an appellate court should be doing than perhaps might even be the traditional appellate role where they correct legal errors. In my view, that leads him to suggest different outcomes than the majority on somewhat frequent occasions. I don't think that's bad. I think there ought to be room for different philosophies, and I think there ought to be room for expression of them. The parties who end up with Justice Beislein on their side probably think it's a good thing too. And I think there is benefit for the future in having those dissents, because they certainly tell lawyers studying those cases something about what the other view is.
Mr. Justice McQuaid, go ahead, sir.
Mark, I have listened to the assertion that Justice Shepard is biased and prejudiced, and to that end, I'd say that all of the members of the court must draw upon their background as to some basic philosophies, which is along the line that Phil has been talking about, the way we draw members of our court from the populace and place them in these positions. And they are not trained specifically from the day that they entered grade school or high school or the university to become members of the Supreme Court. We select them in a different way, and of course, not knowing whether you're going to be a member of the court, you have to engage in a pursuit of life that may be a little contrary to someone else's posture. But by and large, what we've done is to have an appellate body consisting of five people from the state of Idaho to review these opinions on strictly a basis of law, not as to whether they think the facts are right or how they can draw from the facts, because in the main those have already been formulated. So what we're only looking at is an application of law to these facts. Now, and it's in that sense that I've referred to that these are technicians. They're technicians in the law, and they apply the law as they find it to the facts.
I'm sorry, I'm going to have to interrupt you there. Unfortunately, we're out of time. Justice McQuaid, thank you for joining us tonight. Mr. Barber, we thank you, sir.
Thank you.
Mr. Shalladay, Mr. Lewis, and Moscow, thank you, gentlemen. We appreciate it. That's our time for tonight. We'll be back tomorrow. I'm Mark Johnson. Good night.
The funding for this program is provided by the Corporation for Public Broadcasting and the Friends of 4, 10, and 12.